In Florida, filing for divorce is legally called dissolution of marriage, and Florida is a no-fault state, meaning the petition only has to state that the marriage is irretrievably broken, not prove fault by either spouse. This video walks through the full process: the residency rule, the 2 tracks Florida offers, which forms are involved, the filing fee, how service works, and what happens on the way to a final hearing. Before anything else, Florida sets a residency requirement. At least one spouse has to have lived in Florida for the 6 months right before the case is filed. That's proven with a Florida driver's license, a Florida ID card, or a voter registration card issued at least 6 months before filing, or if none of those exist, a signed affidavit of corroborating witness, Form 12, 902I, from someone who can testify to that residency. Florida also has no legal separation as a distinct legal status. Couples who want to live apart without divorcing rely on private agreements rather than a separate court filing. Once residency is met, Florida offers 2 distinct tracks, and picking the right one before starting saves filing the wrong forms. The simplified dissolution track uses a single joint petition, Form 12, 901A, signed by both spouses together. It's only available when there are no minor or dependent children together, the wife isn't currently pregnant, property and debts are already agreed on, neither spouse wants alimony, and both spouses are willing to give up the right to trial and appeal and attend one final hearing together. The regular dissolution track uses the standard Form 12, 901B series instead, filed by one spouse, called the petitioner, and served on the other, called the respondent. This is the track for any case that doesn't meet every simplified requirement, including cases with minor children, unresolved property, or a request for alimony. Which exact version depends on the situation. Form 12, 901B, 1 if there are minor children, Form 12, 901B, 2 if there's property but no children, or Form 12, 901B, 3 if there's neither. Along with the petition, most Florida divorces involve a handful of other forms. A cover sheet for family court cases, Form 12.928, is filed with the first pleading. A family law financial affidavit, Form 12.902, is generally required unless both spouses waive it in writing. It has 2 versions: the short form, 12902B, for individual gross income under $50,000 a year, and the long form, 12902C, for income at or above that. Every party also files a designation of current mailing and email address, Form 12.915. If a spouse is being served rather than filing jointly, a summons, Form 12, 910A, is issued along with the petition. If there are minor children, a UCCJEA affidavit, a child support guidelines worksheet, a parenting plan, and a notice of Social Security number are generally required as well. And if the spouses have reached a written agreement on property, debts, support, or parenting, a marital settlement agreement, Form 12, 902F, is filed. Virdix asks about the marriage, any children, and the county in plain language, and prepares these forms from the answers, matched to whichever track applies. Florida divorces are filed with the clerk of the circuit court in the county where either spouse lives, not with any state agency. Filing can happen electronically through the statewide Florida court's e-filing portal or in person at the clerk's office. Either way, the forms filed are the same. E-filing changes how they're submitted, not what the court requires. Statewide circuit court filing fee for a Florida dissolution of marriage is $295, under Florida statute section 28.241, though clerks often add a few smaller separate charges at filing, so the total at the counter can run somewhat higher. For anyone who can't afford the fee, Florida law allows filing an application for determination of civil indigent status, along with the petition, and the clerk determines whether the fee can be waived or deferred. If a joint simplified petition was filed, both spouses already signed together, and no separate service step is needed. On the regular track, the other spouse has to be formally served with a copy of the filed petition and summons by someone authorized to serve process, generally the county sheriff or a certified private process server. Spouses can't serve each other directly. Once served, the respondent generally has 20 days to file a written response under Florida Family Law Rule of Procedure 12.14. If there's no response in that window, a default can generally be requested. Florida family law cases also require both spouses to exchange financial information under Florida Family Law Rule of Procedure 12.285, on top of the financial affidavit already filed with the court. Once that exchange is complete, each side files a certificate of compliance with mandatory disclosure, Form 12.932. If the case involves minor or dependent children, Florida law also requires both parents to complete a court-approved parent education and family stabilization course under Florida Statute Section 61.21 and file proof of completion before a final judgment can be entered. The course doesn't have to be taken together. Every Florida dissolution, simplified or regular, ends with a final hearing before a judge. On the simplified track, both spouses attend together, and the hearing is often brief if everything is in order. On the regular track, the petitioner and the respondent, if contested issues remain, appears, and the judge reviews the settlement, or if the parties disagree, holds a trial on what's left. Once the judge is satisfied every requirement has been met, including disclosure and any required parenting course, the court signs a final judgment of dissolution of marriage, and the marriage is legally over once that judgment is signed and filed. If keeping track of all of this by hand feels like a lot, that's exactly what Virdix is built for. The wizard at Virdix.co walks through these same questions in plain language and prepares Florida's dissolution forms from the answers, matched to whichever track fits. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure the paperwork is complete and consistent from the start.